Had on this issue of the amended notice of hearing, it talks about Anna Dow serving as counsel and prosecutor, raising a conflict. You did raise that issue, is that correct?
I raised that issue from my very first board meeting, before I even knew who Anna Dow was, or barely knew who Anna Dow was.
And did you receive written communications from the Attorney General's office in which they indicated to you that they did not believe that that was an issue?
They sent a letter, not a formal opinion, that said that that in and of itself did not rise to the level of not being acceptable.
But you continued your allegations that that was a conflict. Even though you had an opinion.
Banks, I did not say it was a conflict. I said it was a less than desirable situation.
Oh, so just less than desirable. Okay.
Yes. And I think, in fact, I know, as I said in that hearing, I provided the litigation from the State Board of Chiropractors, the Ethics Board, and the, I can't remember the third one now, Dentistry, State Board of Dentistry, all of them entailing the same issue of the same attorney serving in both roles.
And you provide that to the Attorney General's office?
I made reference to it, yeah. In fact, they, in their correspondence back, they made reference to, I think specifically the Dentistry Board.
And then in, I guess, 2011, you sued Sandy Edmonds on a malicious prosecution.
I sure did.
And that was ultimately dismissed, correct?
It was dismissed upon the revelation that it was Ms. Dow who had actually authorized the calling out of Louisiana State Police terrorism unit to my home.
Did you sue Ms. Dowd for malicious prosecution?
I have sued Ms. Dow for defamation.
And what defamation did she, what words of defamation was she involved with?
She made the statement as came out in discovery of the Edmonds matter, that I was engaging in stalking-like behavior.
Were you in fact stalking Ms. Edmonds?
I wasn't stalking anyone, and that's the reason for the lawsuit.
So the issue involving Anna Dow was some words that she used in which she communicated to whom, do you know?
Yeah, she didn't identify the person, but the communication went to some party at the Attorney General's office.
For some reason, I thought the lawsuit against Anna Dow had something to do with Barbara Bonnet.
That initially was the initial complaint. Excuse me. We had a hearing in September of 2011 involving a special motion to strike and preemptive exception of no cause of action. At the time, Judge Caldwell denied the motion to strike and said to amend the pleadings to clearly demonstrate Ms. Dow having defamed my character. The Barbara Bonnet aspect continues to be an aspect of the defamation suit. The amended pleadings included the calling out of the Louisiana Terrorism Unit of State Police, which I had no knowledge of. At the time I initially filed the petition, I was unaware. And Ms. Dow stated on a videotape that she had no idea who had called police.
Barbara Bonnet filed it against the board?
Against the board.
Okay. And then you sued Anna Dow over that issue?
I did.
And what was the failure on the part of Ms. Dow related to that?
She made no effort whatsoever to substantiate the allegations that were contained in Ms. Bonnet's letter before she permitted it to go before the board. None. And she readily admitted that.
So,
Ms. Bonnet was not happy. Mr. Gwynn was far from alone in people that were livid about me supporting HB 1439. Ms. Bonnet was equally livid. You may recall the auction in Thibodeau. It was her auction.
well, this is what it says. This is your response to what this lawsuit's about. Says suit regarding absurd claims made by auctioneer Barbara Bonnet, which were completely false and malicious against plaintiff as a result of his steadfast opposition to shill bidding in Ms. Dow's proceedings with presenting that garbage to the Louisiana Auctioneer Licensing Board without any independent investigation whatsoever of Ms. Bonnet's claim.
That's what I said, yeah.
That Ms. Dow should have not presented that information to the board?
I think Ms. Dow had an obligation to confirm any element of validity on it, and she readily admitted she did not do so.
Go ahead.
There's still the third one, and that is Ms. Dow. That is a mere statement that I believe it is not a desirable setup to have the same attorney serving as general counsel and prosecuting violations. That is not going after.
Did you ever feel that the fact that you had received a written response from the Attorney General's office, that they found no problem with that particular setup, did you ever feel that that information should be communicated at the same time in which you were alleging that she had a conflict?
It was communicated, Mr. Bankson. I gave them a copy of the report, it's not an opinion, a letter. I said, and I'm virtually certain that I said in there, although they said that in of itself presents no conflict, as evidenced by the litigation involving the Board of Dentistry, Chiropractic Board, and Board of Ethics. It opens the door for problematic litigation. It's no different, Mr. Bankston. I know you're not an accountant, but it's no different basically than having the same person who is reconciling the accounts receivable ledger, being in charge of making deposits, reconciling the bank account. It's just not a good setup. Is it illegal? No. Is it advisable? In my opinion, absolutely not. And that's as far as I went, was to express my opinion, which apparently wasn't permitted to do.